State of Ohio versus Russell Farrow. That's case number 18CA011327. The appellant has waived oral argument on this, so we will just be hearing from the state. Attorney Murphy representing the state this morning. The court has read the briefs in this matter and are ready to proceed if you are, Attorney Murphy.
Thank you.
You'll have 15 minutes.
Thank you, Judge, and good morning, judges. What the state wants to draw this court's attention primarily to is the fact that the trial court was not wrong in its decision not to suppress evidence. However, what the state wishes to further emphasize to the court is that the grounds for the trial court's decision needn't necessarily have been correct, just that it was wrong. And the reason the state says that is because the state believes that the trial court was correct in finding competent, credible evidence that the Ohio's Highway Patrol Trooper Timberlake had probable cause to search the vehicle. First of all, that Sergeant Timberlake was qualified in smelling marijuana through his 25 years with the Ohio State Highway Patrol and his prior experience in smelling the odor of marijuana, both fresh and burnt, in this case burnt, according to the evidence, by sticking his head into the car 3 times, seeing a couple air fresheners, which contributed to his belief, or gave grounds to his belief that the occupants were trying to mask the smell of some odor, in his opinion, marijuana. And that he had just smelled marijuana within the past week. He had testified through his time on the road there. Also, the cigar wrapper that he testified Mr. Farrow said had contained marijuana, unprompted, which gave it a higher level of credibility, that statement. So the competent, credible evidence supported the trial court's finding that probable cause existed to search the vehicle and to search Mr. Farrow's person based on the precedent of State versus Moore, which I'm certain the court's very familiar with. What I wanted to draw the court's attention to, though, more chiefly, is the second assignment of error regarding the prescription pills. Certainly, the way the situation could have unfolded, which might have made this a little more clean as far as the fact scenario goes, is if Sergeant Timberlake had searched the car first. So upon believing that there was the odor of marijuana in the car, gave him the probable cause to search the car. Had he found the 9 prescription pills, what turned out to be oxycodone, in the car, might have made a search of Mr. Farrow much more clean as far as the fact scenario goes. What actually happened, though, was Mr. Farrow came out of the car at Sergeant Timberlake's request, and Mr. Farrow's holding some kind of clothing, according to Trooper Dowler, as if he's concealing something in his waistband, Mr. Farrow, or trying to conceal something somewhere. It's at that point that the troopers raise with Mr. Farrow a question, and it's, well, what do you have on you? And Mr. Farrow says, oh, no, nothing. He pulls something out of his waistband area. I think it was Kleenex or a napkin or something like that. And they say, hey, there's still something there. Well, what's there? And Mr. Farrow pulls out an unlabeled prescription pill container. It's unlabeled, and he says that there's medicine in it. At that point, no search had occurred. No frisk had occurred, no pat-down had occurred, and certainly no search had occurred. Mr. Farrow produced that pill bottle unlabeled, which is a first-degree misdemeanor, possibly, but certainly would have given Sergeant Timberlake probable cause to believe a misdemeanor was committed under Revised Code Section 371908 uppercase E, altering, defacing, or removing the label from a container in which a prescribed controlled substance is dispensed or supplied while the original contents remain in the container. If those aren't the original contents, those pills that were, the pills that were in that container, then the alternative probable cause is that Mr. Farrow is illegally in possession of a controlled substance. What that controlled substance is, being pills, would be a scheduled substance, and is also either at a minimum a first-degree misdemeanor, a Schedule 3, 4, or 5 under 292511, or is a felony offense if it's a Schedule 1 or 2 controlled substance. So it's at that point that there is now probable cause to conduct a search incident to the arrest of Mr. Farrow. So when there's more pills located on Mr. Farrow, there's some evidence that one of the troopers didn't go into Mr. Farrow's clothing, but started to touch the clothing and feel it. Whether the court believes it's a frisk, a pat down, or a search, at that point, a full-out search would have been warranted, based on the way the events actually unfolded. Of course, the alternative theory is the officers had probable cause, or the troopers had probable cause at that point to search the vehicle. They found prescription pills in that vehicle. Certainly would have believed that one of the two or both occupants were in possession of those pills, and would have led to the discovery of the pills on Mr. Farrow inevitably. So there's a whole lot of ways to get to the point of the law enforcement finding those pills on Mr. Farrow. And really the other way is, under precedent, the troopers had the ability to remove the occupants of the vehicle during the traffic stop until they could complete whatever they were going to do during that. And Mr. Farrow, had he just gotten out of the car, the situation unfolds where he's again concealing something on his person, and that same situation unfolds in which he's pulling stuff, officers noticing something that appears to be a bulge and pulling items, then Mr. Farrow is out of his clothing. So ultimately, what the state wants to emphasize to this court is that upon a review of the dash cam, the initial finding of the pill bottle and the substance that was in that pill bottle was not found as a result of a search. For the reasons that we've explained here, and there are alternative and multiple reasons to affirm the trial court's decision, both that there was competent and credible evidence to believe Sergeant Timberlake's testimony of smelling an odor of marijuana in the car, and then also that the discovery of the pills in no way violated Mr. Farrow's constitutional rights.
Counsel, does standing have any place in this scenario,
Your Honor,
since he's the passenger?
I don't believe so. I think the case law is pretty clear that Mr. Farrow has a right against unreasonable searches of the vehicle, even as a passenger in the car. I don't think that's an issue.
Anything else? All right, thank you very much. We'll take the matter under advisement, issue a decision in due course, and once it's released, the clerk will certainly mail you a copy of the decision, as it will to Attorney Bortner. Thank you for your argument today.
Thank you, Judge.